Hello everyone, welcome to our video on co-owned patent disputes in Vietnam. Today we are going to explore a fascinating topic that affects inventors, innovators, and anyone interested in intellectual property rights. Have you ever wondered what happens when two individuals collaborate to create an amazing invention, but only one of them is recognized as the inventor and owner in the patent application, while the second is just named as inventors? In such case, what are the key takeaways? Well, that's precisely what we'll be diving in today. Under Article 86 of the Law on Intellectual Property of Vietnam, the rights to register invention belong to specific individuals and organizations. Let's take a closer look. If an invention is jointly created by two inventors in Vietnam, both of them have the rights to file a patent application. However, there is a catch. They must provide adequate proof that they meet the requirements set by Article 86. This means they must show that they either individually created the invention through their own efforts and resources, or they have a mutual agreement to file the patent application together. But what happens if one of the co-inventors doesn't have the right to file the patent application? Well, in that case, the other co-inventor may need to step in. They have to provide evidence of an agreement that grants them the right to file the patent application. If they can't provide such evidence, or if the patent application is filed without proper authorization or ownership, it may be rejected or invalidated. Now that we understand the legal consequences, let's delve into the step for determining the entitlement to file a patent application for jointly created invention in Vietnam. First, it's crucial to identify all the co-inventors who have contributed to the creation of the invention. Each co-inventor must be named in the patent application as inventor and owner. I must emphasize here, and owner. Next, the ownership rights of the invention must be determined. This can be established through an agreement between the co-inventors or based on the contributions made by each co-inventor. Once ownership rights are established, the right to file the patent application needs to be determined. Normally, the rights to file lies with the inventors or co-inventor who created the invention through their own labor and expenses. However, if the invention was created with the help of others, such as the organization or individual who provided funds and material facilities, they may also have the right to file the patent application. To safeguard co-inventors' rights and ensure their entitlement to file a patent application is respected, there are some important steps that they can take. First and foremost, it's crucial to have a written agreement with other co-inventors regarding ownership and the right to file the patent application. If there is no agreement or disputes arise, it's advisable to consult a patent attorney or intellectual property specialist for legal advice and guidance. When filing the patent application, all co-inventors should be listed as joint applicants to ensure equal ownership and rights. In cases where one co-inventor files a patent application without the consent or agreement of the other, the affected co-inventor may challenge the application through opposition or third-party observation. They can also request a determination of the right to file a patent application with the IP Vietnam. If the patent has already been granted, the other co-inventor may challenge its validity by requesting a patent invalidation. Lastly, we need to address other important considerations for co-inventors. Issues like patent exploitation, payment of royalty or fees, patent assignment or licensing, and determining ownership proportions should all be carefully addressed in the agreement between the co-inventors. And it's important to establish clear guidelines to prevent disputes and ensure fair treatment. Before we wrap up, let's quickly touch on the interpreting agreement with the foreign governing laws. Under Vietnamese law, parties in an agreement can choose which national law should regulate the agreement. Choosing an overseas law is acceptable as long as it doesn't contradict the fundamental principles of Vietnamese law. In such cases, the interpretation of the agreement will be based on the chosen overseas law. And there you have it, a close look at jointly created invention in Vietnam and the right to file a patent obligation. Remember, understanding these key considerations can help you protect your intellectual property rights and prevent potential legal issues. Thank you for joining me today. If you found this video helpful, don't forget to like, share, and subscribe for more informative content. Until next time, take care and keep innovating.